docket number SJC-13574, Commonwealth versus James W. Ferguson.
Okay, Attorney Tomkowski.
Good morning, members of the court. Michael Tomkowski for James Ferguson. I'm asking the court to order a new trial for Mr. Ferguson for a couple of reasons. The primary one being an issue that you addressed in O'Brien, addressed in the previous argument, but I'll address it again, which is that Mr. Ferguson was entitled to an instruction on involuntary manslaughter based on a couple of different theories, which, though perhaps not compelling, certainly not conclusive, were theories that the jury could possibly reasonably have reached if they had been instructed that that was a legal possibility. So the two separate theories, one that involves Mr. Ferguson being inside the house and one that does not. So if Mr. Ferguson, if the jury found he were inside the house, there was still the argument that was raised both below by the trial attorney and here on appeal, that the injury to, the fatal injury to the victim was essentially unintentionally inflicted upon him. That the other injuries, while horrific and of course not something that the defendant would be proud of, the question is what was the injury that killed the victim? And the evidence, I would say actually the compelling evidence, quite frankly, was that that was the injury to the arm that severed the artery that caused all the blood loss that created in the scene being seen as quite horrific, which of course it was. And if that's the case, that the arm was the fatal injury and the other injuries were not, then what was argued below and is argued here is that it was certainly not impossible that that injury occurred because the victim attempted to flee out the window of the spare bedroom when the defendants were not inside.
Where do we draw the line between impermissible speculation and in the light most favorable to the defendant? This theory that it must have been he cut his arm on the window.
So
when he's fleeing.
And it's not he must have been, but could have, I guess, is really how I'm framing it. And where you draw the line is it's a question of simply of logic, and it's not necessarily something I can articulate with any precision. But I think what is true in this case is that the Commonwealth painted a picture of what they thought the physical evidence showed, but that, quite frankly, was speculation, maybe a reasonable inference, but certainly not the way it had to be. There really isn't a lot of information about how things actually took place in the house, who did what when, where people moved at different times. This is all basically just arguing inferences from where blood was found, where other evidence was found. That's what the Commonwealth did.
Was there any evidence that, which would be, I suppose, in the form of an opinion, that the injury to the arm was what alone led to the death?
Well, I believe the testimony of the medical examiner was that the injuries to the head eventually would have caused death, but that the injury to the arm would have resulted in death within a matter of minutes. And so that I think the jury could infer was the actual cause of death. That without medical attention, he would have eventually bled out from some of the other injuries he sustained, but that arm injury was just quickly fatal and therefore was the first, essentially, or prominent cause of death. And so the theories that were argued below and are argued here is that either, again, if Mr. Ferguson was in the house, that the victim sustained that injury fleeing or during a struggle that did not involve the use of a weapon, the victim stumbled into the window and cut himself on the arm. So either of those two possibilities would support a theory of manslaughter, either that it was an assault and battery where the window was not intentionally used as a weapon, or that simply the conduct of breaking into someone's house and being violent with them was reckless.
Was the window theory argued below? Raised below in the request for involuntary manslaughter?
Well, it was discussed in the context of the closing that we don't essentially know how the arm injury was sustained. There was a request for an involuntary manslaughter instruction based on the idea that, I believe it was raised, Your Honor, I guess to answer your question, that
I guess we'll look at the record, but so was there a charge conference and then?
there was. And so counsel
And what did
requested.
counsel say? I want an involuntary manslaughter because?
And I have to go back to look at the specific language on that, Your Honor, but it was generally the theory that the jury could infer that the victim was either trying to escape, or I believe he also argued that he could have been pushed sort of without a simple assault and battery. It caused him to fall into the window. But the use of the window was unintentional. I believe both those arguments are made below, but if I'm wrong, you'll certainly correct me on that, Your Honor. But certainly that was, and distinguishing this from O'Brien, which of course the court has already made a ruling on, I think that the fact that it wasn't raised in O'Brien at all is significant, and the court frequently makes a point to say we need to raise these issues below because once we're up here, the record just isn't developed sufficiently. In O'Brien, not only was there no request for the instruction, it was, I think, expressly disavowed. And the theory in O'Brien's case was that he wasn't even there. And the jury wholeheartedly rejected that and convicted him on I believe all three theories of first-degree murder. And so here, essentially it was an all or nothing strategy. And then on appeal, the argument was, well, there should have been an involuntary manslaughter instruction that nobody ever asked for, or at least nobody pressed. And that's just not the situation here. So I think that the fact that the defendant made the argument below, raised a proper objection, and continues to make that argument here, that puts him in a different light than O'Brien. I think there's also an additional theory, again, not necessarily one that the court thinks the jury would have necessarily adopted or that is even the most compelling. The idea that Mr. Ferguson, while present and certainly a participant, at least in the concept, did not actually enter the house. I understand there were 3 sets of shoe prints. The only shoes located in the case, which were entered into evidence, did not match the only shoes of Mr. Ferguson's that were located and entered into evidence. The shoe prints did not match any of the prints that were found in the house. The items that were connected to Mr. Ferguson were found outside the house, and both those items also had connections to Mr. Mascaratolo as well. So it was the glove that had, I think, a little bit of blood on one of the fingers that had both Mr. Ferguson's DNA and Mr. Mascaratolo's, and then the golf shirt where the evidence was that was a tournament that Mr. Mascaratolo had participated in, did have Mr. Ferguson's DNA on it, but I think the jury could have inferred, they could have chosen that it was either one or the other.
So the theory is that the act is wanton and reckless as opposed to an act of malice, but it has to be they beat him senseless with the fry pan, the foam in the fry pan, and then when he gets away from them and he smashes through the window and cuts his arm.
Well, that's one possible theory under which there would be a wanton reckless.
Okay, what's the other possible theory?
That he was pushed and he fell into the window unintentionally. And the third theory is that if the jury could infer that he was not in the house, that Mr. Ferguson was not aware of the extent of the violence that was going on.
When he was pushed and fell through the window accidentally, he was pushed post being beaten senseless with a fry pan.
I'm not sure that we can really say exactly the order that everything happened, Your Honor, quite frankly. I don't know that I think the evidence supports any number of sequences of the events, and we can't really say for sure whether the pan attack happened before or after the window.
Well, we know the pan is ante-mortem. We know the pan attack was before he died, and he died of sanguination from blood loss.
Understood, but he didn't die instantly. And so again, I say it's more likely the pan attack happened before he went into the window, but I don't know that the jury had to find that.
So he cuts his arm, he's bleeding out, then they beat him with the pan?
I mean, we don't know. So it may seem sort of illogical, but on the other hand, he cuts his arm, and he may not be immediately disabled and may be continuing to resist. There's no way to know. There's no way to know exactly how things happened.
Well, the issue that I keep going back to with some of these theories is, how is a trial judge, or what are we telling trial judges, the framework for deciding whether or not these lesser includeds, if there's no real shape to how you animate in the light most favorable to the defendant? Because with all due respect, I know you're doing the best that you can, but it's like, it could be this, it could be that. They could have looked at this way, they could have looked at that. I mean, how is the judge supposed to take all of that? And are we going to look in the record and say, at the charge conference, Judge, here are the facts that came in at trial, and here's our theory and how those facts fit our theory? Or is it just, I don't know, the gleam in the lawyer's eye about what could have, should have, would have happened, and we should get this lesser included?
No, I mean, if there has to be some, it can't be sort of against the laws of physics or the universe, right? I mean, if there's a video of what takes place that shows, you know, the three defendants smashing the guy through the window, you know, and then that causes the cut to his arm, then I don't think a judge is going to give an instruction on involuntary manslaughter under those circumstances.
Well, how about these circumstances with the physical evidence that we have here? Was that squared to the trial judge as to how it supports any one of these theories?
Well, I think that the critical fact that most supports the idea that he might have fled into that bedroom is the fact that there are no shoe prints found and only bloody footprints. And so I think that particular piece of physical evidence supports the idea that
would you agree that hitting someone over the head with a fry pan 4 times is evidence of third-pronged malice and not wanton and reckless conduct?
Yes, except for the fact that the jury did not have to accept that that was the cause of death. And so that conduct would, if it resulted in death, would certainly be third-pronged malice. I would concede that.
It has to do with one's mental state, right?
I'm sorry?
It has to do with mental state of the defendant as opposed to the cause of death, right?
Well, I think the defendant has to have that mental state, but I think if it doesn't result in death, then it would sort of be a moot point, right? I mean, in other words, the defendant may engage in conduct that creates a likelihood of death, but if it doesn't actually result in death, I don't think that is the theory under which a murder conviction would be sustained. It is the act that results in the death that my argument would be that that's the act that has to be analyzed in terms of whether that act was malicious, not
So
sort of the overall conduct.
So if I'm near a railroad track and I shoot at someone and I try to kill them, I do my best, I'm a bad shot, and the person flees and gets run over by the train, right? My intent is an act of malice, right? I've committed an act of malice, correct?
If you shot at someone, you did, yes.
It's not, and the train kills the person.
Your Honor, maybe, I don't know. I think that, respectfully, that there wasn't the situation here, so I don't know that I can really say without thinking about it a little bit more whether that would be first-degree murder exclusively. In other words, do you not get a manslaughter instruction under those circumstances? I'm not sure. So essentially, again, the framework here is important, and the question that Justice George has asked, is how do you instruct trial judges? Essentially, I think that's sort of what kind of guidance can we give them? And I don't know that there's any more guidance that the court really needs to give, except that it's take the evidence in the light most favorable to the defendant. And so, even though the Commonwealth's case here as to murder was certainly sufficient and maybe more than sufficient, that's not really the issue. The issue is there any rational view of the evidence in which this was not a third-pronged malice situation? And my argument is that there was, for the reasons that I articulated.
So your argument is, if I understand it, is if the victim had died as a result of the 4 blows with the frying pan to his head, your client would not have been entitled to an involuntary manslaughter instruction. But because there was this intervening event of going through the window, he was.
That's correct, Your Right. So the idea, I mean, he unattended, any injury, and of course, could in theory eventually result in a blood
But
loss.
that's why I asked you
Yeah.
whether there was any evidence that said that the cut to the arm was the sole cause of death. But I heard you to say no.
Well, the medical examiner said, I believe the testimony was basically that both contributed, but that the head injury was a much slower.
It would have taken longer, but it was still, he did not exclude it as the cause of death.
Was not excluded. But the question is whether the jury could have, I think, is the question, not whether the medical examiner
So, well, unless there's evidence, I don't see how the jury could have unless they resorted to speculation. That's why I'm asking you, is there any evidence that, well, I don't need to repeat my question.
Sure. I think so. So I think the jury, where the medical examiner says either of those two could have been the cause of death, is not a definite science, right? I think the jury would be free to use their common sense and say, actually, it was the severed artery in the arm that caused the death, and that the head injuries, while serious, did not. I think the jury would be free to reach that conclusion. I think that the extent of blood found in the house supports the theory that the arm injury was severe and caused most of that blood to be dispersed throughout the various rooms where he traveled. So I think the jury could have found on those facts that it was the arm injury that was the fatal blow.
So we'll have to go back and look at the transcript to see what trial counsel argued to the judge about how this could possibly be involuntary manslaughter.
I think that will be an important part of your review, yes.
But I guess I want to make sure I understand your argument. Your legal proposition is, if this man were in his bedroom getting beaten such that he tried to do what anyone reasonable would do, and that is escape, and that if his method of escaping was to think about going through that window and it unfortunately ends up severing an artery and dying, that intervening fact would inure to your client's benefit in getting an involuntary manslaughter instruction.
So a benefit is sort of, I understand why you're using that word, but
It could only be a benefit to me that if I'm beating somebody and they run and they get hurt such that whatever it is that you're claiming is the cause of death, you're not even saying it's a contributing, you're saying that if that were the case and the jury accepted that version of your theory, that it's the artery severing that resulted in his death, that intervening component would give your client an involuntary manslaughter instruction.
Well, I don't think it's intervening if the jury could have found that the victim would not have died but for that act of going through the window. In other words, if none of the other injuries were themselves fatal, then the jury could have found that the window was the but-for cause of the death. And so it's not an intervening act that essentially changed the proximate cause from one injury to another. I think the jury could have found that was the cause of the death. I guess that's the best way I can answer that question, Your Honor. Does that make sense?
It does. Thank you.
If there are any other questions on this issue or any other issue, I'm happy to answer them, or I can rest on my brief.
Okay, thank you.
Thank you.
Attorney Hanson.
Thank you. Good morning. If it pleases the court, Arne Hansen for the Commonwealth of Massachusetts, representing the Plymouth County DA's office. Today, I ask that you uphold the defendant's conviction for murder where he wasn't entitled to an involuntary manslaughter instruction because, one, there's certainly substantial evidence of malice here which would support the murder conviction, but also this was a felony murder case where the victim died during the result of a botched robbery, which would also preclude him from getting that instruction.
Well, you still get an involuntary manslaughter in a felony murder case nowadays, right, after Brown?
Right, okay, so I'll step that back. With respect to the malice portion of it, it's very clear here that the evidence supports that they intended to at least do grievous bodily harm to the victim. as well as third-prong malice, where they should have known, given the extent of the injuries and the beating that they inflicted on
I
this.
think opposing counsel's argument is that that actually didn't cause the death, or at least under the theory that he
Right.
jumped through the window.
Right, so that's entirely based on speculation. I think the evidence was very clear that the medical examiner stated in its transcript 8, page 61, the victim died of blood loss. What contributed to the blood loss was the 4 lacerations to his head, as well as the severing of the artery. I think the evidence was clear that both of which would have been independently fatal.
Did he use the independently fatal language?
I'd have to go back and look.
All right, we'll look at that. What was argued below in the request for manslaughter instruction?
I don't have those specific facts.
I'm sorry. I'm really frustrated. You tell me you don't know. You tell me you don't know, and that's the issue. So both of you are here arguing the central issue to either affirmance or reversal, but no one can tell us exactly what defense lawyer argued at the time of trial? No one has that at the tip of their tongue?
I don't. I apologize. Now, with respect to the evidence left at the scene, there was substantial evidence that tied this defendant to the actual beating and robbery of this victim. He was wearing a blue shirt that originally belonged to Moscartolo that was saturated in the victim's blood. His wearer DNA was retrieved from the collar of that shirt as well as the armpits, which suggests that it's more than him just touching that shirt at one point and his DNA getting on it. He's clearly intimately involved in wearing this shirt as the victim is bleeding all over him. This is important because it implicates him either in the beating of the victim, or he's carrying this victim as he's bleeding out, as they're carrying him throughout the house looking for the items that they want to steal. So this demonstrates that he either had the intent to cause grievous bodily harm, or certainly should have known that this individual, the victim, suffered catastrophic injuries that would have caused a risk to his life. I think
I'm sorry, what's the evidence of carrying?
the victim was clearly, there's blood all over the crime scene.
Including the victim's bare footprints, though. So
Correct. So
that's why I'm wondering
maybe
why you're
carrying was the
saying
wrong word.
carrying.
But they were escorting him throughout the house, presumably where their footprints are in his blood. So he's certainly in close contact with the victim. Now, with respect to the felony murder portion of it, the defendant argued that the victim, or that he wasn't present in the house while all of this happened, and he didn't know that they were going to end up killing this victim. That doesn't specifically matter where he is a willing participant in the robbery. And there is substantial evidence presented at trial that he was a willing participant in this robbery, where he planned it with Moscartolo ahead of time. He has 2 phone calls with Moscartolo as they're going down to the victim's home. They shut off their phones almost in unison. Then he participates in the robbery at the house, and he continues to participate after this victim is grievously injured. The Eagles case is very illustrative on this point as well. If you don't know that your co-venturer is armed, but you find out during the commission of that felony that they have armed themselves, even if it's with an improvised weapon. In the Eagles, it was the victim's pillowcase that was used as a ligature. Here is the victim's frying pan that was used as a blunt object to beat him over the head, as well as the window. If you find out that after the weapon is used, you continue to participate in the felony, you have the requisite intent for that homicide. So even if he wasn't involved in the actual beating, which is the point the Commonwealth doesn't concede and is arguing the opposite, he's still guilty of the murder where he continues to participate. He sees that the victim is bleeding out on the ground, the house is covered in blood. He doesn't call 911. He doesn't disassociate himself from the criminal conspiracy. He does the opposite. He collects the firearms with O'Brien, drives up to wherever he spent the night, and then delivers the firearms to Moscartolo the next morning.
Can I ask you to go back to the cause of death? Opposing counsel's argument is that the jury were permitted to conclude based on their common sense, despite what the medical examiner said, that the exsanguination occurred because of the 4-inch gaping hole in his armpit. Can I ask you to address that?
Right, that was in evidence, but it wasn't the only piece of evidence.
No, I know, but given, I'm sorry, I thought we were still on the involuntary manslaughter instruction. If that's to be given, we need to view the evidence in the light most favorable to the defendant. And if it's possible for the jury to conclude based on their common sense that the victim bled out because of the injury caused by the window, as opposed to the frying pan beating, why is that not the cause of death leading to an involuntary manslaughter instruction?
So to get the involuntary manslaughter instruction, it needs to either be wanton or reckless conduct, or it could be a killing that is a battery that didn't amount to a felony. So a simple assault and battery, such as just punching someone with your fist, and if, like the Catalina case illustrates this point, where it was a large victim, or a large defendant, small victim, punches the person once in the face, that the victim falls down, hits their head on the sidewalk, and ends up dying as a result of hitting the sidewalk. In that case, it was clear that no weapon was used. It was just the defendant's fist. So that was involuntary manslaughter. A felony battery would include a weapon. In this case, the argument would be the window itself was the dangerous weapon that was used to cause the injury. So that would be it would be an assault and battery dangerous weapon, which is a felony. So just pushing someone through the window is the weapon, which creates the felony. Does that address your question?
I guess so.
Are there any additional questions?
Doesn't look like it.
Thank you. Commonwealth rests on its feet.